has given a suggestion. Just like the independent directors in a company, you can have a civil society participation, and he also gave the example of a jury system that is in operation in England, in the United Kingdom. This is for the people who are in power to take note of. And coming to Mr. Vishwanath, he must be having a serious grievance with land acquisition. Now, land banks were created by the governments in anticipation of foreign investment. See, ultimately, funds, money is a centripetal force that guides every action, whether it is human beings or organizations. So all these factors of production, be it land, labor, capital, whatever, unless you have control over it, nobody is interested in doing it free of cost. If you ask somebody to do something without a motivation, he will never do it. There must be some motivation, and that is the basis of the privatization. And then at the same time, that person who makes money, look at the people who are billionaires. They have been philanthropists as well. So question is, take action to meet the need, meet the growing situation. Now everyone has on the panel has accepted that privatization has come to stay. It is not a necessary evil, it has done good. But they are only saying that don't miss the element of public welfare as contemplated in Article 30, Part 4 of the Constitution. Now the suggestion, the next speaker, Mr. Dr. Puneet, spoke very eloquently on how the judiciary is deriving many unenumerated fundamental rights as against the enumerated fundamental rights, and reducing the definition of state when it comes to implementation of those enforcement of those fundamental rights. So he spoke of horizontal effect being given, where you give a definition of the state to include all those institutions who are performing public functions. It's not just the National Review Committee on the Constitution which gave this suggestion. That suggestion is based on what the Supreme Court said in Praga Tool's case. That's if you are performing a public duty, then you are answerable under Article 12 of the Constitution of India. So, in conclusion, I would say that what Jeremy Bentham said, greatest happiness for the greatest number of people. That's the object of a welfare state. No doubt, development is not the object of our Constitution. Public welfare is the object of our Constitution. And what Dr. Vishwanath said, what is development without welfare? And lots of books are written on development economics and welfare economics. There's always been a discussion, there's always been a thesis and antithesis, and we are trying to arrive at some synthesis. Therefore, I'm sure the speakers have thrown enough light on the thesis and antithesis, and it's for our policy makers now to decide how to bring about a synthesis.
While introducing First Amendment to the Constitution, and thereby we have introduced the two notorious provisions, Article 39A and B of the Constitution. In fact, nowhere in the Constitution we find, at one point, that is why the Justice, so the Hidayatullah said, it is the only Constitution in the world which requires protection against itself. So that is why to protect against itself. So the Supreme Court devised the theory of the doctrine of basic structure, because you know that our Constitution, as Glanville Austin said, so that consists of so many conflicting, inconsistent provisions, and it is the only society in the world that can accommodate so many conflicting things. So anyhow, so then what is this? What exactly this basic structure theory implies in terms of our political theory? So it is meant for the purpose of limiting the powers of the Parliament to amend the Constitution. That is why you know that Supreme Court in Keshavanand Bharati's case said that so the Parliament has no power to amend Part 3 of the Constitution so as to alter the basic structure. It may be because that so that the Indian Parliament, we have different procedures. In fact, in no other constitutions there was no substantive limitations as to even Indian Constitution. We don't have substantive limitations as to the power of the Parliament or any other designated body to amend the Constitution. But in India, so the Parliament was given, in fact, a complete power to amend Part 3 of the Constitution. That is the why, in fact, that we have this problem. So that in terms of real income, the gap between rich and poor is increasing, and thereby, in fact, so the globalization cannot promote what is called as the political idea of redistribution of income and wealth. However, the proponents of globalization have argued that unless you have income, what you can redistribute if there is no income at all? So that is why the policy of globalization is based on what is called wealth maximization or wealth creation. So then, of course, we are able to, in terms of economic growth, so the wealth has been created. In fact, more wealth has been created in the era of globalization than in earlier socialist period. But at the same time, in fact, the benefits of the so-called wealth created in pursuance of economic policy has not been. In fact, but coming to in pursuance of globalization policies, so the certain programs, policies of the government have been questioned before the court on the ground that they violated fundamental rights or they have reduced the scope of judicial review. In fact, in so many cases, of course, basic structure theory at one point of time confined to the review of constitutional amendments was soon extended to.
This is Mallikarjunaya JM. I am the principal of KLE Law College, Bangalore. KLE-Society established in 1916 with an Anglo-vernacular school in Belagavi. Today spreads across the borders. It has its institutions all over India and abroad too. Today there are about 252 institutions with 1,25,000 students and 16,000 faculty working in the saga of education. KLE-Society was kind enough to provide a beautiful infrastructure for its law college at Bengaluru with 7 floors with the state-of-the-art facilities provided makes the learning a joyful experience. In this wonderful campus, we have now organized, on the eve of KLE Centenary celebrations, a national conference titled Post-Liberalization Nuances of Indian Constitution. In this conference, there are over 700 students and delegates participating. There are 30 resource persons and over 170 papers being presented. The seminar is inaugurated at the auspicious hands of Honorable Mr. Justice B.S. Patil, and the keynote address was delivered by Mr. Aman Hingorani, the Advocate of Supreme Court of India, and our own beloved Director, Mr. S.I. Munavalli, gave the presidential remarks on the occasion. In this conference, we will be deliberating about the policies that the government has adopted in the post-liberalized era, and are those policies in tune with the constitutional fundamental objectives. If the globalized policies or the policies in the globalized period, governmental policies in the globalized period, if they are not in tune with the constitutional goals, what is the way out? Do we come out of globalized policies? Do we mend them to meet the constitutional goals? Is what is going to be deliberated through for 2 days by many technical sessions with the help of resource persons. For example, we would be deliberating on the issues like privatization versus public welfare. Is privatization good to ensure public welfare is what we would be discussing. And the Constitution of India has the core principles and the core principles have been explained in the doctrine of basic structure by the Supreme Court. Whether the doctrine of basic structure that was evolved by the Supreme Court, which said basic structure cannot be amended by the Parliament. Without amending the basic structure, if the damage has been caused to the Constitution or otherwise is the query that is often raised, and the resource persons would be deliberating upon this issue too. Additionally, the issues like media and privacy and compatibility of constitutional goals with the IPR and corporate laws and certain various other aspects would be discussed in this conference over a period of 2 days. I am happy to share little information about KLE Law College, Bengaluru. KLE-Society has given a wonderful campus to this college recently, which was inaugurated on July 23rd, 2016 at the auspicious hands of Honorable Minister for Finance Arun Jaitley ji in the presence of many policymakers. At this college, we offer 3 courses in law called the BBA LLB course, BA LLB course and the 3-year LLB course. The candidates and the aspiring students who want to pursue their legal profession would come and join readily, being this college being the top ranked college in the country. And we do create a perfect ambience for their learning by conducting the classes through the use of multimedia resources and also by introducing many clinical methods. Thank you.
Of a pragmatic approach, you can, liberalization is not inconsistent with the basic structure, though of course with the caveats around it. Anybody else? Excellent judges. The difficulty is not so much the judges as the structures in which the court is placed. Now suppose, the way I was pointing out, in S.P. Gupta or the other cases, you have PIL being extended, the jurisdiction being extended to bring everything within the domain of the court. And there are no standards, then there is bound to be subjective exercise of power. If there is subjective exercise of power, it's going to be an arbitrary exercise of power. In the process of the implication of keeping a matter as a PIL and a non-PIL is that within the common law system there are checks on the judges. You have to lead evidence, you're bound by the pleadings, you cannot raise issues which are not there in the matter. It's an adversarial system. In a non-PIL case, in a PIL case, there are no checks.